All right, let's go to trade secrets. I've touched on it. Trade secrets getting more and more attention all the time. Texas now has the Uniform Trade Secrets Act and has for some time. We now have the federal Defend Trade Secrets Act. So now you can file, if you want to file in federal court, you've got a trade secrets claim. It basically gives you that option. So trade secrets. Well, what's a trade secret? It's pretty intuitive. An obvious example would be something like, here's an offshore rig, and if you've got some confidential seismic data about some offshore gas deposit that nobody else has, that's a trade secret. And if you keep it secret, it's a trade secret, which it has to meet 3 requirements, basically. Number 1, it has independent economic value. Number 2, it is not readily ascertainable by competitors, right? If a competitor could go out and easily find the same information, it's not a trade secret. Number 3, the employer has to take reasonable measures to keep it secret. Okay, so it's easy to understand in a case like this offshore oil rig, but the situation I see more often with trade secrets deals with what I call soft trade secrets. And by soft trade secrets, I basically mean 2 things: customer lists and prices. Customer lists and prices are probably the most common things you see people arguing are trade secrets, right? Now, the thing about that is everybody's got customer lists and prices, right? So there's a certain danger here that we turn trade secret law into effectively a de facto non-compete, right? Because if I can't use information about customers and prices that I know, I can't compete. And you'll see employers now, even when there's not a non-compete, they will use this trade secrets theory to stop employees from competing. I've done it myself. My firm had a case. We had, this was in a company that did maintenance and repair of electric transmission lines. They had some employees leave to start up their own competing company. They didn't have non-competes. We sued in federal court in Austin and argued that they violated the Federal Defend Trade Secrets Act because they had taken sensitive pricing information. And the argument that we made, that gets made in these cases, is that if you have confidential information about the company's prices, you can use that knowledge to undercut the company, right? If I know exactly what the company is charging and I know who its customers are, I can go to the customers and say, hey, I know what you're paying my old company. I'm at a new company now. We can make a better deal for you. You can undercut the competition and take those clients. Now, it's important to recognize that price undercutting generally is okay, right? That's capitalism, right? That's free markets. We want companies to undercut other companies. That's a good thing, right? Am I right about this? But what you can't do is use secret price information that you gain while working for the company to do that. But where do you draw that line? That's a difficult problem. And I think we're going to see more and more litigation about this, and courts are going to struggle with figuring out when price information is a trade secret and when it's not. Let me give some suggestions. One thing to look at is look specifically at the industry. How often do prices change? If prices change on a daily basis, it makes it a little harder to argue that the information is a trade secret, because 2 months out it may have no independent economic value. Also, if prices are widely publicized in the industry, are there industry publications that publish prices? That's an important thing to look at. So you got to look at the specific industry to figure this out. What kind of product or service are we talking about? Is it something highly specialized where a lot of thought goes into the pricing? Or is it just a commodity? If it's just a commodity, it's probably a little harder to argue that the price information is a trade secret. So that leads to my practice tip, which is understand the client's industry if you're dealing with the price undercutting theory. Because that's going to help you identify the facts, whichever side you're on, that you need to focus on to either make the case that the price information is a trade secret or that it is not. Now, as you can probably gather from what I've said about it, it tends to be a fact-intensive issue. And most of the time, whether a customer list or a trade secret is whether a customer list or pricing information is a trade secret is going to present a fact issue for the jury. Most of the time, that's going to be the case. It's going to be very rare that either side is going to get summary judgment on that issue. Case in point is SP Midtown versus Urban Storage. This is a case coming out of Houston. There's a photo from Google Maps of this company, SP Midtown, a self-storage company in Midtown, Houston. And this case illustrates, two things. Diverting customers and price undercutting. Diverting customers, what do I mean by that? So you had a manager at this self-storage place, and there was evidence that before he left the company and went to a competitor, customers were coming in and saying, okay, I need a 10 by 15 storage space, and he was, no, we're all out, sorry. But I'll tell you who you can go to. Sends him to somebody else. And guess who that was, right? So you've got the classic situation of the employee diverting customers before, while he's still on the company payroll. Bad idea, right? So you had customer diversion. Then you also had an argument of price undercutting. The argument was that the employee, he had access to all these rental logs that identified who the customer was and what the customer was paying. And so the argument was that allowed him to undercut the company when he left. Well, the trial court judge didn't agree with that argument and granted summary judgment that this information was not a trade secret. Okay, that went up on appeal, and the Houston Court of Appeals reversed. They said there was enough evidence to raise a fact issue on whether this information was a trade secret. And so it illustrates my point that most of the time, we're not going to get summary judgment on that issue. The court also looked at the diversion issue, and specifically, the court looked at, was there evidence that the defendant company conspired with the employee to breach the employee's fiduciary duty to the company? And the Court of Appeals said that there was also a fact issue there, because you had a situation where the employee was breaching his duty to the company by diverting customers to the competitor while he's still employed by the company.